Welcome to the Semi-Interesting Podcast, where we explore some of the unique legal issues in the global semiconductor industry. My name is Nathaniel I'm an IP attorney at the law firm of Hodgson Russ, and one of your hosts.
My name is Elizabeth Morris. I'm an IP attorney and the Director of Intellectual Property and Products at Pure Storage in Santa Clara, California, and I am one of your hosts.
No industry, semiconductor included, is immune to the threat of patent trolls. These patent assertion entities or non-practicing entities will demand licenses on patents with dubious validity or questionable provenance. This has become part of doing business, unfortunately. Legal teams must spend time and money on letters, licenses, or even invalidation procedures. As we talked about on a previous episode, some asserted patents are from defunct startups or solo inventors, but some are from larger companies, even your competitors, that sold off unwanted parts of their portfolio. So this need not be an outside threat that you're worrying about. The call may be coming from inside the house, so to speak. Today, we discuss Lot Network, which is an industry organization trying to lessen the impact of what patent trolls can do. And we're joined by Lew Zaretzki from Lot Network and Sam Wiley from Ocean Tomo to learn more. Lew and Sam, thanks so much for joining us today. Before we get into some of the deeper questions about how this all works, why don't the two of you give a quick introduction to yourselves?
I'm Lew Zaretzki. I'm an IP strategist. I assist very large tech operating companies and tech investors in matters of IP strategy. I do this in part on behalf of Lot Network, where I lead the 5G Transparency Project, which is looking at the 5G SEP world. And one of my focus areas is semiconductor.
And my name is Sam Wiley. I'm a managing director with Ocean Tomo, where I lead the analytics practice and co-lead the technical services group called IP Specialty Services. And I also used to be a colleague of Lew's at Lot Network, where I was the head of thought leadership and partnerships until just a few months ago when I joined Ocean Tomo.
Thanks so much, Sam and Lew, for being here. Sam, I know we've had a relationship because my company was actually, very early on in being part of Lot Network. Lew, since you're, really the one focused on representing Lot here, can you tell everyone else what Lot Network is? Who runs it? How did it start? What's it all about at a kind of a high level?
Lot Network is a nonprofit entity that's been put together by a group of over 4,000 companies who collectively hold over 20% of patents in force. And the purpose of Lot Network is to allow these companies to reciprocally share rights under their respective portfolios. They do this in order to inoculate themselves and others against any risk should any of these patents wind up in the hands of PAEs in the future. Meanwhile, they preserve their ability to use their patents and portfolios for any and all other purposes that they may have. It's purely voluntary, and Lot has really no other activities other than to maintain this agreement and share it with others.
And Sam, Ocean Tomo's not exactly a small name, but could you give us a quick introduction to what it does and how it fits into the IP ecosystem?
Sure. So Ocean Tomo is a little similar to Lot Network in that it's really a platform for solving IP problems, but it's a consulting firm that's focused solely on IP. We're part of JS Held, a bigger organization that is also involved in scientific and technical consulting. Ocean Tomo is a neat organization. It was really one of the first companies that think about IP value separate from all the other different types of assets out there. Our founder, Jim Malachowski, was one of the first people to really think about IP valuation as its own special thing. And he did it at a really good time when sort of at many companies, intangible assets, including IP, started becoming the majority of the value. We do just about everything. So every part of the IP lifecycle we can help with. So if it's looking to file an invention application, if it's looking to sell a patented invention, if it's looking to license, all the way to a lot of our experts really do damages testimony, really calculating the value of a patent when it's in litigation. Ocean Tomo can help in along all of those different avenues for the IP lifecycle.
Thanks, Sam, and thanks, Lew. Those were great introductions. I do want to dig in a little bit more on law network. So 4,000 plus is a lot, and 20% of the patents in force today, that's a big chunk of kind of what's out there. So very impressive. Is it free to join Lot Network? And you said it inoculates against risk, but how does it really work? What are the reasons that people like to join or maybe also don't like to join?
Yeah, sure. So for many companies, it's free. The rate card is based on company size, and the highest rate for the largest companies is $20,000 per year. Now, how it works is one can review and enter into the lot agreement. This is even possible to do online, where you can work with someone at lot and go through it with them. And when you execute the agreement, you are effectively promising to grant a license under any patents that transfer from your portfolio to a PAE in the future to all of the other members. And in turn, you receive the same from all of the other members. This continues as long as you remain in the lot network. And so new members continue to come at a rapid pace. You continue to gain rights under their portfolios and they under yours. The actuality of a license only occurs if one or more patents from the network are transferred to a PAE. A PAE is a term that we all probably think we know, but it's actually defined in a very specific way in the agreement. So maybe we should have given it a different name just to make clear that it has a very specific definition here that might differ from what you might have ordinarily thought.
And Elizabeth, if I could just add a little bit of a few thoughts to that. One of the great things about Lot Network is it's a voluntary market-based solution. A lot of us probably listen to this podcast, certainly all of us on the podcast, we think intellectual property is important. We think there's a place for patents and we think they add a lot of value to the economy. One of the thoughts around Lot Network was that if there was a problem, which could have been this thing which you might call non-practicing entities, NPEs, or patent assertion entities, PAEs, having too much activity, having too much impact on operating companies, then Lot Network was conceived as a way for these companies to solve that themselves without having to go to Congress or regulatory bodies or take other avenues that might have an impact over on the overall patent system, the overall IP system, if you will, and really solve it on their own. That was what was really I find really fascinating about Lot Network and why I think it's such a powerful platform.
When we were talking with the two of you before we started recording the podcast, you actually had a really great analogy about how patent assertion entities or PAEs perpetuate IP issues between traditional companies that I really liked. I wanted to make sure we talked about it because it was easy to understand. So could you try to explain a little bit with the analogy we talked about earlier?
Sure, I'll take the more colorful approach, and then maybe Lou can explain how it works in the real world. But especially with the semiconductor industry, I always think of it as kind of like an Old West saloon. And there's a cowboy sitting at the bar, and a cowboy is about to take a drink from his whiskey, and all of a sudden he gets hit in the shoulder by a bullet. And he looks up and he isn't sure who did it, but he thinks he knows who did it. So he pulls out his own gun and he starts shooting and he hits somebody else. And it creates this mess, right? Everyone's shooting, everyone's fighting, and everyone's not quite sure who shot at them, but they're going to start shooting again. It becomes kind of the classic circular firing squad where everybody is suffering and nobody is really getting much out of it all. And it analogizes real well to NPE behavior in the semiconductor industry because, and I'll let Lou explain how this really works in just a few moments here. But, company A will sell, or let's say actually settle a licensing agreement. They'll be sued by company B and they'll give company B a few patents as part of the settlement. Company B then sells those patents to NPE. The NPE sues company C. Company C only sees that company A originally invented this patent. That's who they think it came from. And so they think company A caused the problem. They go and maybe they sue company A, maybe they sell patents to an NPE themselves, hoping that teaches company A a lesson. And it really creates this vicious cycle that a lot of companies would probably rather not be part of, or at least have a rather more sane approach to it. And that's the analogy. It's kind of this firefight at an old timey saloon. And one of the things we're trying to do with Lot Network, or that Lot Network was trying to do, I should say, is not have that happen.
Yeah. So Sam, we talk about it in the semiconductor industry, and this really extends beyond semiconductor, but I think semic is the field where the behavior seems the most pronounced to me. What we see, let's just go back in time to, the first real example I studied of this years ago was Mossade. And so Mossade was a Semic startup, and they fell on hard times operationally and became a licensing entity, an NPE. And they ran a campaign starting with their own patents. And I'll give you some events between 2009, 2011 that really illustrate the way this cycle works. So they had sued Micron, and this concerned DRAM patents. They settled with Micron in February 2009, and as part of that, they negotiated the acquisition of 500 US assets or so a couple months later. Now, the campaign continued to Samsung, and about a year later, they settled with Samsung, and there, presumably, they would have leveraged the Micron patents they had acquired in addition to their own patents, unless Samsung was already licensed to those. But they got the settlement with Samsung, and they negotiated 130 US assets or so a few months later. The campaign continued on to Hynix, and now they have in hand their own portfolio, plus those of Micron and Samsung that they've acquired in this very campaign. If Hynix wasn't licensed, they now would need to pay royalties on all three of those. In May of 2011, they agreed to a settlement, and they transferred to Mossade around 180 US assets a few months later. And so now Mossade, which began with its own portfolio, now has portfolios under the three largest DRAM companies, as well as its own. And the campaign continued, and they licensed quite a few others as well. Now, Hynix shortly thereafter sold around 100 US assets to Intellectual Discovery, another PAE in Korea. So if we take a look at this process, what we see is that each of these companies, Micron, Samsung, and Hynix, probably recouped some of its royalties through the sale of patents to Mossade. And each of them enriched the Mossade portfolio, probably increasing the likelihood that others would have to pay and pay more. Hynix came third and probably had to pay the most. And Hynix probably looked to recoup some of that by making other sales, such as that to Intellectual Discovery, which probably resulted in spinning up a whole additional cycle with Intellectual Discovery asserting those against various other companies, which then sought to defray their royalty expenses by paying in kind with more patents, and probably took a shot at wherever they thought the shot came from by maybe setting up another PAE to assert in retaliation, just like in your, classic Old West shootout. Now, with Lot Network, if any one of these companies, like Micron, had joined Lot Network, it still could have participated in the cycle in the exact same way that it did. But if a second company like Samsung joined, then Samsung would not have worried about whether Micron took a shot at it in this way and wouldn't have had any reason to fire back at Micron. But if another company like Hynix joined, then they again would have been inoculated against the portfolios of the first two, and they could have just dealt with Mossade in typical fashion. And if they wanted to transfer patents to Mossade as they did, it wouldn't have resulted in any more sort of counter retaliation from these other companies in the network. And so Lot Network could have been a way for these companies to attenuate this vicious cycle, still getting whatever rights they needed from Mossade for fair value, but not increasing Mossade's activities and increasing the value and the cost to them.
And something that I think is really important to note is that one thing Lot Network doesn't do is prevent these companies from licensing or otherwise monetizing their own patents themselves. So Lot Network only prevents the situation that Lew's already described, which is selling a patent to an NPE and then that NPE suing a fellow Lot Network member. If one of these companies felt that it was necessary to license their patents or their technology to one of their competitors, one of their peers, or even just an adjacent company, there's nothing about the Lot Network agreement, I should say, that would prevent them from doing so.
Yeah, that's right. And there have been some classic wars among lot members. That maybe one of the most interesting was the Google Waymo technology leader who left, formed his own firm, and sold it to Uber. Google and Waymo alleged that he took important trade secrets with him. And so Google and Uber fought sort of a nuclear war over this while both being in the lot network.
Yeah, I want to dig into that a little bit more and maybe also back to Mossade. So, how do you as a LotNet helps figure out which lawsuits between members are really practicing entity against practicing entity lawsuits as I think we would all agree Google and Uber qualify in that category versus Mossade, which maybe um started out as a practicing company but turned into something that looks a lot more like a patent asserting entity company. There must be some gray area there that is a challenge.
Well, it really goes to the agreement and how the lot agreement is drafted, and within that, how it defines what is a PAE. So lot doesn't really have to make any choice about whether one lawsuit is okay or another is not. It simply defines what party is a PAE and who is not. And so a PAE would have to be somebody generating, well, I'm gonna really make this radically more succinct, but I encourage everybody to read the agreement if they have deep interest. A company earning a preponderance of its revenues through patent licensing is a succinct way to say what is a PAE. And so Samsung, Micron, Hynix, none of them would come anywhere close to that, even if they have a huge licensing business. On the other hand, Mossade, once it wound down its operating business and once it grew its licensing business, would qualify as a PAE.
I'd be curious to hear Lou's thoughts on this. I think the number of companies in the world that could reasonably fall into a gray area where you really would need to look at their internal business documents and financial statements to know for sure if they are a PAE or an operating company is relatively small. It's some biotech companies that may be doing a lot of licensing before they get their drug approved. Some companies that have a technology package they license out, and maybe it's not 100% clear if the revenue is tied to the technology package or to the patents that underlie it. Might sometimes fall in a gray area. And even then, and Lou, I'd love to hear your explanation of this. There's sort of a part of the lot network agreement that addresses that. So if you're a company and you're very successful at licensing your patents, but they relate to a viable product that you sell or a viable service, then that's actually excluded from the revenue. Could you talk a bit about that, Lou?
Yeah, well, so the important thing to remember is that the law would allow a license defense. And so imagine that Micron and Samsung had been in law at the time of this Mossade cycle, and Mossade had brought a Micron patent to Samsung. And Samsung might say, well, we believe that we hold a license to this patent by virtue of our joint membership in the law network. And so, here we can see the evidence of Micron's membership and our membership at the right time and the patent transfer to you. And we maintain that you, Mossade, are a PAE under this definition. And so if there were a dispute, they could bring all that forward and presumably ultimately prove, or perhaps Mossade would disprove that it meets this PAE definition if there were any question about that.
Would a company potentially like Mossade maybe meet one definition at one point in time and another definition at another point in time as their, amount of earnings coming from one area or another changes? Do you determine that at the time of the lawsuit? How does that affect things?
Well, you're right. That's what I personally call sort of a transfer in place. In other words, the patent hasn't been sent from one entity to another necessarily, but the entity itself has transformed into a PAE. And so that can happen. Again, the agreement defines exactly if or when it would happen. But let's just imagine that a company had 1 billion in revenues from products and it followed a path down to zero. And let's just imagine that at the same time it had a patent licensing business that started at zero and grew to 1 billion. And so somehow they crossed in the middle. And so under the agreement, one would be able to ascertain, if or when a trigger occurred that caused that entity to transfer in place. And so, I mean, I can't remember enough about the history of Mossad, but I believe they did transfer in place once upon a time, maybe in the early 2000s or something like that.
And again, it's a pretty rare circumstance. I think that those unique circumstances might require closer reading of the lot network agreement than the vast majority of them.
Yeah, but it's, attorneys can surmount this matter if and when they need to, simply through a thorough review of the agreement and the details of their situation.
You both have given some great examples relevant to the semiconductor industry. I'm curious if you've had any recent successes or recent growths in the semiconductor industry that you can share.
Well, the thing that we're the most excited about lately, two companies joined recently in the semiconductor industry. One is Global Foundries, the famous foundry that was spun out of AMD back in the 2009 vicinity, if I recall. And so they operate a network of fabs around the world in Germany, the US, Singapore. And so Mott is quite proud to have Global Foundries on board. Now, we're equally proud to have ASML, the famous Dutch maker of EUV equipment, which has become so essential on the leading edge these days. And so, in order for people like TSMC to make leading edge semiconductor process offerings, they need ASML's EUV equipment. It's a linchpin of the industry, and they've joined. And so Lot now is working to bring in the rest of the foundry industry, people like TSMC to join with Global Foundries, as well as the rest of the equipment industry with people like Applied Material, KLA, Lam. We'd like to have all these people join.
Yeah, and just another pitch for sort of the market-driven nature of Lot Network. What I think is so great is that no one's being compelled to join. There's no national governments forcing anyone to do anything they don't want to do. It's really these companies making a decision that they see as best for them when they join. And I just think that, again, it really speaks to why the Lot Network approach is so effective.
Yeah, I'd like to dig in a little bit more on that, like your plans to grow the semiconductor industry now that you've gotten Global Foundries and ASML. And maybe this goes back to a question earlier that I feel like you dodged a little bit, which is why do companies not join? Why are there companies on the fence? If the cost of joining LotNet is pretty low and it takes some risk off the table, why do you only have 20% of the patents of the world and not, 95%?
Right. Well, we think 20 is really good, but yeah, we're certainly ambitious to add more. So we often ask ourselves the same question. There are a few basic reasons that you can imagine, right? So first of all, if you're a PAE, or if you have a de minimis operating business where risk mitigation is not a concern, well, then there's that. Secondly, if you are, I'll use the term pessimistic. If you believe that there is some likelihood or risk that your operating business will decline and that you will need to switch to a PAE model or an NPE model, then you might say it's better to keep your options open. Now, if you're an optimist and believe that you will be growing your operating business, then your risk will increase, and therefore risk mitigation should be of greater interest. But, as every person has a personality, every company does, and some will be optimists and others will be pessimists, and they will arrive at these different conclusions.
I think another reason sometimes companies don't join isn't because they're opposed to lot network or necessarily planning to sell patents to a patent assertion entity anytime soon. It's just they have different priorities. For example, a pharmaceutical company may not right now have a lot of MPE activity to deal with. They have lots of other important IP problems. So whoever's in charge of making big IP decisions at a pharmaceutical company might be interested in Lot Network, but it might not be a super high priority now. One thing that Lot Network was seeing, especially during my tenure, and I can only imagine it's become more intense, is this idea of technology convergence. So every company is becoming a technology company. Banks are technology companies. Pharmaceutical companies are technology companies. Drug companies are using AI to develop new treatments. they're using technology to communicate with research labs all over the world. So a typical pharmaceutical company is looking a little bit more like a tech company every day. That could attract NPE activity, and that might make lot network more important to take a look at. But sometimes it's not necessarily something that they're not interested in doing. It just isn't the highest priority at the very moment.
It's very true. And I could point out a couple things on that. So there's sort of a mini convergence in semiconductor, and some of the large lot members include Amazon, Google, and Microsoft. And all these people are making their own silicon today, particularly in the area of ML training and ML inference, but sometimes in some broader areas that underpin their cloud services. And so these are effectively large semiconductor companies today. They're just not merchant semiconductor companies. So there's a convergence even within SEMIC where non-SEMIC become SEMIC companies. But you're right, Sam. Back in the day, it was things like voice over IP, right? You could just be a company that has phones, and you wind up getting targeted by VoIP patents from PAEs, and it was legit. And so why not get into a collaboration with the people that create those patents or have large portfolios and inoculate yourself at virtually no cost.
Do you see industries kind of going together? I can imagine if you're a smaller player in the semiconductor industry, for instance, that, and if you don't have big NPE problems, then maybe you hadn't thought to join LotNet, but now that you see some big players joining, it might be more attractive. Is that part of the strategy?
Yeah, so Lot landed a few beachheads over the years that were part of its sort of growth strategy. And the first beachhead was, we'll call it software and cloud, and included people like Google and Dropbox. Then subsequent beachheads included the automotive industry, the financial services industry, and the retail industry. And so in automotive, virtually all the Western OEMs of any size are in, people like Honda and Toyota and Daimler and so forth. Within the financial services, basically all the Western large banks, people like JP Morgan Chase and such. And within the retail industry, big retailers like Macy's, people of that ilk joined as well. And so what happens is you usually start out with one leader, one visionary. They join, that creates value for others to follow, and they join in turn. And so we're hoping that Global Foundries and ASML can be visionaries of that sort for the next beachhead in semiconductor.
I want to go back a little bit. Sam, you were mentioning pharma and drugs a little bit ago. We also talked about what would be sort of a healthy level of activity. And you gave another great analogy involving blood pressure that I'd like it if you could throw back in.
Yeah, no, I mean that this is sort of my point of view and only my point of view. So maybe not every lot network member would agree with this, and maybe not lot network itself, but I see the patent system as being very important and being sort of a living body, and maybe patent activity, patent litigation, patent licensing is, if you think of that as your circulatory system with blood. Well, there's a certain amount you want to be healthy, right? You want a certain amount of transactions, a certain amount of activity to happen. If it gets too high, maybe bad things start happening. If it's a human body, maybe you have heart problems or problems with your blood vessels. And I think if you look at sort of what may have been happening around the time Lot Network started, a lot of companies felt like NPE activity was too high. They thought the awards that they were getting were too high. It was impacting their business functions, and so you had to look at medication, right? And I think Lot Network is a blood pressure medication that brings down the amount of activity, but doesn't completely eliminate it. And I won't go into all the other examples of things you might do, but I'll just say some of them are a lot more like surgery. They're going in and they're dealing with a problem very directly and having a big impact on the overall system. So, if you take blood pressure and you lose weight and you get into good shape, then your blood pressure comes down and you don't need to go and get heart surgery. If you do have heart surgery, there's going to be side effects, and that may impact the overall health of the system. And I think that's what's so great about Lot Network and why I think it does make sense for a lot of companies to really consider joining. Because if we do reduce that overall blood pressure, if you will, then maybe some of these other things that do impact our ability to have an amazing patent system aren't necessary anymore.
Yeah, it's a great analogy. I totally agree. I think that everybody at Lot would have to agree with that. And one of the Lot members who joined a while back was Bayer, the German pharmaceutical and chemical company. And this was their exact view at the time. Their view was they want a strong patent system because the patent system is a result of statute and legislation. It's affected by law and politics. And so they wanted to take the pressure down in the system where possible through private action, so that there wouldn't be attempts at this radical surgery that might damage the strength of the patent system for its intended purposes, like developing life-saving drugs.
Well, you can't argue with life-saving drugs. Um, but I do want to go back a little bit to the semiconductor industry here. So, it does seem that, LotNet might be more effective in areas where there's a lot more, traditionally, anyways, a lot more NPE lawsuits happening. Isn't it more relevant to, software and electronics than to chip design and capital equipment? I mean, certainly from my time in a capital equipment company, it appeared to me that the trolls usually had no idea what it was that my company was really doing, and so mostly left them alone.
Yeah, you could call that sort of security through obscurity, right? You're not really safe, but just nobody knows you're there, and you hope that they will never find out. But that's not a great plan. I mean, it can be fortunate as long as it lasts. There is a lot of PAE and NPE activity in semiconductor, and there has been for a long time. And, we're not even saying there's anything wrong with that. But it's a fact of life. And so many might find it worthwhile to mitigate risk, prudently where possible. And, another example, we talked about Mossade and there are others like them. Another example worth mentioning is IP value. And IP value has largely built its business in the semiconductor industry, bringing in large portfolios from a number of large semiconductor companies and licensing them out to other such companies. And I think on the website, when I looked recently, they mentioned that in their existence, they had brought in over $2 billion in royalties, of which they distributed around 1 billion back to their sponsors. The sponsors being the people contributing the patents. So in more recent times, Intel contributed a very large portfolio, something like 4 or 5,000 patents, into an entity called Tahoe Research that IP Value manages. So you can imagine they had rolled up a number of such agreements with people like Intel and raised this 2 billion and shared back 1 billion with them. And so, however you slice it, 2 billion's a lot of money. And so I don't think we can say there's no risk.
And I will say, this idea of technology convergence, it's always interesting. I'm a big RPX and Power fan. I really like their data sources. And, it's just fascinating to me because you'll see a single patent and the kinds of companies it's asserted against will just be all over the place. You'll have Macy's and United Airlines and a sandwich chain and a semiconductor company and Microsoft and Google, 30 plus companies all in the same patent. And it really speaks to technology convergence. Every single one of those companies is using the same technology to communicate with their employees, with their customers, the same websites. It's a different world now. And I do think every company, whether or not they ever want to, join Lot or work with Ocean Tomo or do any of these things, does need to be a little more diligent about understanding NPE risk.
Yeah. And this leads to a great point for the semiconductor industry, which is indemnification. And so if you are making a device and selling it on to OEM and systems customers who then sell it on to users, if you've provided indemnification or if you want to provide it because customers are asking and you can add value, well, then these risks are your risks.
So I had a quirky question for you that's a little out of order here. So here's my quirky question if you want to answer it. As a patent attorney, we always talk about how we can be our own lexicographer and come up with our own words for things. And you mentioned earlier that maybe it would have been better if you defined in your license not the definition of a PAE in license terms, but had made up a new word for those entities. So I'm giving you the pen now. What is the new word that you would like to use?
Well, I think in the spirit of good trademark attorneys, I would want to make up a totally unique word so that the only meaning it could possibly have is the one I ascribe to it, thereby eliminating all misunderstandings. And so I think of Novartis, it's now a well-recognized brand, but it's just a word they made up for these very purposes. So I'd have to make up a word, but I guess I'd need counsel to do that effectively.
This doesn't at all answer Elizabeth's question, but I'm a little old school. I find myself just saying NPE more often than not. Even though PAE I think is a better description. It's a subset of non-practicing entities, but I found that at least in our little nerdy part of the world that all of us patent attorneys live in, I feel like NPE is really well understood. Folks know what you're talking about, even though they don't know exactly all the details. I do think it's important that the lot network agreement does have this other definition because there's a lot of NPEs, university tech transfer offices, research labs, companies that do a lot of amazing R&D. They just choose to disseminate their work using licensing that don't fall under the description of PE and certainly are not, part of the problem that Lot Network's trying to solve. So I appreciate the need for the really wonky PE term, but I do agree that it's not as easily recognized as we'd like it to be, and maybe Lou's very strange drug company sounding new name might be helpful.
But like a fanciful term, maybe from older stories that people already know, but isn't really used in the IP industry, like for instance, troll might give exactly the emotional goal you're looking for.
So troll has an interesting problem, I think, in IP, and that's that when we first started talking about patent trolls, it was a goofy term, right? It was a guy who lived under a bridge and he had a big club and he took gold coins from travelers and unicorns and things like that. And then I think the term troll, as it applies to politics and influencing elections and all those sorts of things, it wasn't as heavily loaded as it is now. And so I think calling someone a patent troll in 2025 is a little different than 2010. I think we do need a new fanciful term, and it's probably not troll.
Well, let's say this. I mean, everybody's entitled to their own view based on where they sit, but we're not rendering any kind of judgment over these business behaviors of people who monetize patents or license patents in one way or another. Um, we're just allowing operating companies who voluntarily wish to get together and share these rights with each other for their mutual benefit. And so, God bless IP Value and Mossade for doing a good job at their job, and that's their right, and hopefully their investors and customers appreciate it.
No, and that's a really important point, Lou, that I think sometimes does get lost is that Lot Network is not an advocacy organization. It doesn't have a lobbying arm. It's not meant to be something that, casts judgment on a particular business model. It's just trying to solve a very specific problem for operating companies. And it doesn't have opinions about whether it's a good or a bad thing to be an NPE or Lot Network has members that do feel MPs are kind of a bad thing for the world, and it's got members that think MPs do great work, that they help reward inventors and reward people who came up with great ideas. So there's a diversity of thought even within the Lot Network membership that would makes it so it wouldn't make sense for Lot Network to have an opinion on that.
Yeah, that's exactly right. In the end, it's an agreement, and you can see exactly what's in the agreement anytime online. And effectively on this subject, the definition of a PAE determines when licenses are triggered, and that's all it's about. So, you could say that does something bad have to happen to trigger, or does something good have to happen to trigger? Well, it really doesn't matter. The trigger will classify situations as a license or not a license, and that's all it is.
Lew and Sam, this episode we've covered a lot, and I want to thank you for your insights in what might be a very interesting opportunity for companies in the semiconductor industry. I appreciate the analogies and the frankness and frankly the very diplomatic way that we've ended it in terms of welcoming all different viewpoints underneath the big tent. So thank you both for joining, and hope to have you again to hear an update in terms of your success in the industry.
Sounds great. Thanks for having us.
Thanks so much for listening to this episode of the Semi Interesting Podcast. You can find more episodes wherever you get your podcasts, including YouTube.
And if you enjoyed the episode, we always appreciate 5-star reviews. While we talked about legal issues, none of the information shared during this podcast is intended to be legal advice. If you have any questions about information we cover or ideas for a future episode, feel free to contact me or the other attorneys at Hodgson Russ. You can find contact information at www.hodgsonruss.com.